Hey guys, welcome to this video. This is John Watts. Responding to a comment from Rob C. here, and he and I have had a little bit of an exchange about the frustrating thing is when you're researching the law, you realize that this court over here will rule for example, the FDCPA, Fair Debt Collection Practices Act, that here's the law. But then this other court over here, same law, same set of facts, different result. And that is frustrating. So let's talk about that in general, and then we'll get into the specifics of Rob's comment. So you have the Circuit Court of Appeals, and that's the 11th Circuit, the 5th Circuit, the 2nd Circuit. So you have all these different circuits. And so, for example, where I predominantly practice is the 11th Circuit, and so that's Alabama, Florida, Georgia. You have the 5th Circuit, which would be Louisiana, Mississippi, Texas, I think. And then you have, the 9th Circuit is sort of the West Coast. And, 7th Circuit is going to be like Illinois and some other places. So, Illinois, Indiana. Point is that those appellate courts there, when they issue a decision and say, this is what the law means in this certain type of fact situation, then that binds the district court judges. So when we're talking about federal courts, the district court judge is the trial court. Okay, and so a district court judge in Tampa, Florida, or Atlanta, Georgia, or Birmingham, Alabama, they're bound by what the 11th Circuit says. Now, what if the 5th Circuit says something, or the 9th Circuit, or the 7th Circuit? Well, a district court judge in Birmingham, or Orlando, or Miami, or Savannah, Georgia, wherever, they can look at that, but they're not bound by it. And they're also not bound by other district court judges, even within the 11th Circuit, even within their particular district. So Alabama has 3 districts. We have Northern District, Middle District, Southern District. So you could have 2 judges in the Southern District that come to different interpretations of the law. And that's fine. Now, it's not real common, okay? And even within the 11th Circuit, let's say a judge in Miami has ruled one way. Well, a judge in Atlanta, Georgia is going to look at that and not bound by it, but they'll certainly give some weight to it. And but then what do we do when we have these what's called a circuit split? So the 11th Circuit rules one way, the 9th Circuit rules another way. Well, ultimately, that's part of what the Supreme Court does, is they step in where there's a split among the circuits, and they say, now let us tell you what the law is. So with that little bit of background, let's look at what Rob's saying here. He says, been reading up on circuit cases regarding debt collection activities and whether or not a debt collector reports to a CRA, credit reporting agency, consumer reporting agency, is in violation of the FDCPA when the debt collector received a validation letter within the 30-day window. And then he references some case law here that you have different interpretations on what is collection activity. Just to remind you, if you get a letter from a debt collector, what's called 1692G letter, sometimes called the validation letter, and that will give you 30 days to dispute the debt. Now, you can dispute the debt anytime. You can dispute it verbally, but this is a special type of dispute where you request verification. Now, again, courts sort of interchange these terms. People call this a debt validation letter. Technically, the debt validation letter is what you get from the collector, and then you send a request for verification, but these terms get all jumbled up. So point is, within that 30-day period, you respond back to the collector and say, give me verification, give me proof, give me validation. Well, they cannot continue to collect until they provide that verification or validation. So what Rob's saying here is that there's some kind of disputes among the courts as to, well, what if they are reporting to a credit reporting agency? Is that considered collection activity? And so he ends up with this, which is a very good point. He says, I suppose that is where I'm getting at when I mentioned the FDCPA was not applied fairly across the board, varying interpretation, circuit split. That's absolutely right. So what do you do as a consumer? Well, let me actually start. If you're a consumer lawyer, you've got to understand in your circuit what is the appellate court law. So what does the 11th Circuit say? I need to know that. And then I need to know, what do the district courts within the 11th Circuit say? Okay, so even though I don't practice in Florida, I'd like to know, what do judges in Tampa, what do judges in Miami say? What do judges in Atlanta say? I'd like to know that. And then certainly I need to know, what do Alabama district court judges say? And then wherever I file the case, so let's say I file in Northern District of Alabama. Well, it's certainly useful for me to know what Southern District of Florida, the Northern District of Georgia, it's Southern District, Middle District of Alabama. But it's really important to know, what do the judges in the Northern District of Alabama say? Because, for example, I want to know what Judge Proctor says about this, particularly if I'm in front of Judge Proctor. Because if I've got the same case that he just ruled on 6 months ago, that's going to be his starting point. And, well, let me look. Now, judges can always change their mind, and I've had judges do that, both in a way that helps my client and hurts my client, where they say, I know this is how I ruled before, but I'm reevaluating it, and now this is the better way to approach it. But the point is, I look at all that as a lawyer. Now, as a consumer, you certainly want to know, again, what does your circuit say? What do the district courts say if you're doing this on your own? And then what in your particular district? Now, you can also look outside, because it may be that where you are located is sort of the minority view. And that can change to the majority view, but it may also be an indication if, let's say, your judge has ruled one way and then the next 40 decisions go the other way, well, it's quite likely that your court is going to change its mind and say, well, the overwhelming weight of authority is against me, so I'm going to sort of get in line with everybody else. So, again, there's a lot of research involved, and there are conflicting opinions. The highest level courts are those appellate courts, so First Circuit, Second Circuit, 10th Circuit, all the way through the 11th Circuit. And so that's the most powerful type of case law out there. But you also want to look at where you are physically located and what are judges saying. And look, I look at stuff happening in Northern District, California. I don't practice there, but sometimes that gives me ideas. Or I can say to my judge in Alabama, look, here's a decision from California. It's very persuasive, and I've had judges where they adopt what other courts have said. They go, hey, that's very good reasoning. I'm going to rule the same way. So anyway, Rob, great question. And look, anytime that you run across an opinion and you have any interest in me sort of reviewing that or analyzing that, just send that to me. And probably the easiest thing is just to look it up in Google Scholar and copy and paste that link, because sometimes spelling's a little different, or somebody will say this is from the Fifth Circuit, it's really from the Third Circuit. It just makes it easier for me and others to find it. So just put that link in there. Or if it has a case number, like it might say 900 F3rd 1273. Great. Just put that in there. It makes it easy to find. And but again, fantastic question and observation, Rob. And definitely keep researching, keep looking at this. And, we can look at it, and trust me, I do. I say, this is very frustrating. There's differences. It also keeps life from being too boring. So think about it that way. And appreciate it, guys, and I'll talk to you soon. Bye-bye.